Welcome to This Explainer. Okay, if you've ever watched a legal drama on TV, you probably picture court cases as these massive, intense shouting matches, right? Surprise witnesses bursting through the doors at the absolute last second to save the day. But today, we're stripping away all that Hollywood fiction. We are going to decode the fascinating reality of how a ton of civil disputes in South Africa are actually fought and won. We're stepping onto the paperwork battlefield. Section 1. Two Paths to Justice. Let's look at how South African courts actually go about solving disputes. Okay, let's dive into this. When a dispute goes to court in South African law, it generally takes one of two very distinct paths. First up, there's an action. Now, this is exactly what you see on TV. A full-blown trial with witnesses physically testifying, lawyers pacing the floor, dramatic cross-examinations, the whole shebang. But then there is an application. And honestly, this is where the real tactical battles happen. An application is a case decided almost entirely on written paperwork. No chaotic, yelling witnesses, just highly strategic, carefully drafted documents doing all the heavy lifting. Now, the absolute core weapon used in these applications is the affidavit. You hear this word tossed around a lot on legal shows, but let's actually define it clearly. An affidavit is essentially a written statement containing facts. But you can't just scribble a casual letter and mail it to the judge. No, you have to sign this statement under oath in front of a commissioner of oaths, so think a police officer or an attorney. You are swearing that the contents are the absolute truth. Lying here, that isn't just a simple mistake. It's literally perjury. This document is the absolute bedrock of your entire case. So the application process isn't just throwing a messy pile of papers onto a judge's desk. Not at all. It's this highly regulated, slow-motion argument where literally every single word counts. It all unfolds in a very structured, three-step written debate. Step 1 is your founding affidavit. Step 2 is the answering affidavit. And step 3 is the replying affidavit. Let's start with round 1, the founding affidavit. This is the crucial opening argument. This first document is drafted by the applicant. That's just the legal term for the person actually bringing the case to court. If we had to translate this incredibly dense legal document into an everyday conversation, it basically says this: here is my story, here is my proof, and this is what I want. The applicant sets the stage, telling the court precisely what unfair thing happened to them and what specific order they want the judge to make to fix it. To pull that off successfully, the document has to pack in 4 specific puzzle pieces. First, it identifies the parties involved. Second, it sets out the chronological story. What happened, who did what, and exactly when. Third, it attaches supporting exhibits. Think receipts, contracts, emails. And finally, it explains the legal basis for the claim. You are quite literally handing the judge the entire puzzle, fully assembled. But here is the critical trap that catches so many people completely off guard. The golden rule of the founding affidavit is this: you must put your entire case here. Absolutely no surprise evidence is allowed later on. You can't just save a dramatic gotcha piece of evidence in your back pocket. This isn't a daytime soap opera. If a fact or a piece of proof is not in this founding affidavit, the court might simply refuse to even look at it. You literally stand or fall by this very first document. Moving on to round 2, the answering affidavit, the defense. So this document is drafted by the respondent, the person defending themselves against the lawsuit. Now that the applicant has fired their best shot, the respondent reads through that first document and answers back. In plain English, their message is, that story is wrong, here is where they lied or got it wrong, and here is my defense. It's their big chance to poke holes in the story and present their own version of reality. And this brilliantly illustrates how methodical the process really is. They can't just write a quick one-page letter saying, yeah, I disagree. No way. They have to go through the founding affidavit systematically, paragraph by single paragraph. For every allegation, they have 3 strict choices. 1, they can admit it. 2, they can deny it. But, and this is huge, if they deny it, they must explain exactly why and provide their own facts. Or 3, they can simply state they have no knowledge of it. Which brings us to the golden rule of the answering affidavit. And trust me, it is a massive danger zone. If you don't specifically deny an allegation made in the founding affidavit, the court will generally assume you agree with it. Silence is absolutely deadly in this round of the written debate. You can't just casually skip over the paragraphs you don't like or don't want to talk about. If you ignore it, legally speaking, you admit it. Which brings us to round 3, the replying affidavit, the final word. The ball is now back in the applicant's court. They get one last chance to read the defense and reply to it, essentially saying the defense they just raised doesn't hold up, And here's why my original story is still correct. Think of this step as cleaning up the debate. It lets the applicant address any new facts or surprise defenses the respondent brought up in round 2. But the applicant has some very strict limits here to keep the whole process fair. They are absolutely allowed to rebut the respondent's defense, meaning they can poke holes in the shield the respondent just held up. But what is entirely forbidden? Introducing completely new grounds for the lawsuit. You absolutely cannot use this final document to suddenly change your overall strategy or toss in a brand new claim you just remembered you forgot about in round 1. So the golden rule for the replying affidavit is incredibly rigid. This is strictly for rebuttal. The applicant can only defend what they already wrote in their founding affidavit against what the respondent wrote in their answering affidavit. Basically, no new tricks allowed and absolutely no moving the goalposts at the 11th hour. Finally, the final word, closing the evidence. Okay, so after all 3 rounds of affidavits have been sworn under oaths and officially filed, the building phase of the lawsuit is completely over. The written evidence is permanently closed, the pages are locked in. Now, and only now, do the lawyers head to court. But remember what we talked about earlier? They aren't bringing live witnesses to the stand. Instead, they argue the case in front of a judge, relying strictly on the documents. The judge decides the final outcome based entirely on the strength, the structure, and the facts frozen within that paperwork. It really hits home just how much immense strategic weight these legal documents carry, doesn't it? A single skipped paragraph, a missed piece of evidence in round 1, or a simple failure to deny a claim in round 2. Any of that can cost you the entire case before you even step foot in a courtroom. Which leaves us with this final thought. If your entire case, your entire fight for justice, rested on one carefully drafted written document, what would you say? Thanks for joining me on this explainer. Keep seeking clarity, and we'll catch you next time.